All right, everybody, Jeff LaBelle here. Just wanted to go over the purchase contract, duty zone, and team duty zone if you are part of a team. So this is not going to supplement, obviously, understanding these documents, reading over them, asking questions. What I recommend is if you've never looked at these before, you need to go over them. You need to take a highlighter, and you need to write down any questions that you have. Look at that, even had highlighter right in front of you like that. Bam! You need to write down any questions you might have. You need to bring them to me so I can address them with you and make sure you understand what you're signing or what you're asking your clients to sign. So this is the new duty zone. It was revised 11/7 of 16, and it goes into our duties to the client and what they should expect from us. So I'm going to kind of stop talking to you as agents and start talking to you as buyers so you have an idea of what you are going over with here. I think this is in focus to some degree here. Some of it may be a little out of focus at the bottom there, but for the most part, it is in focus. So I'm going to start talking to you as Buyer Johnson, and here we go. So, Mr. Johnson, this is just our Nevada Duty Zone. It's, frankly, in my opinion, the most important document you're going to sign with me today. It goes over the fact that I represent you and only you. We're going to elect to have me represent only you in a second, but it goes over my obligations to all parties that I run into in public: fair, honest, ethical, can't be deceitful, fraudulent, or dishonest, and then my obligations to you as an individual. And one of the big things here is confidentiality and obedience to you. Obviously not doing anything against the law, but things that you instruct me to do that are within our code of ethics and the law. So this just says I represent you. I'll have you initial here because we are going to write an offer on a property that's already represented, and I'm going to have you sign on your on the top line here. Now, agents, I did this for illustration purposes. You'll see that seller and buyer appear on the same form. That means this form was completed at the time of writing the offer. The real estate division wants to see that you've completed this form as soon as practicable. That's that fun word the division made up many moons ago. As practicable. So when you start to show them homes, when you start to go out and look at things, this also kind of gets the ball rolling for them signing documents with you in the future. So you should have this signed really when you start to show homes, not 2 seconds before you have them sign the contract. That's division is going to look at that kind of stuff if you're ever called into question. So this is a supplemental to the duty zone. This just would list here if you were on the team. The way I present this is, Mr. Buyer, since I am on the team, this is the list of the other agents on my team. Essentially, we all represent your best interests. We all have to take care to protect you in the transaction. Here's our actual purchase agreement, Mr. Johnson. You'll see here our purchase date. This should be filled in. I apologize. Purchase date. Your name is spelled correctly? Yes, perfect. And we're buying 8224 Vista Colorado Street, Las Vegas, County Clark for $420,000. This is all auto-populated, agents. Okay, so this is once you put in the MLS number, as you put in the template in Transaction Desk, it will auto-populate. Mr. Buyer, it says here that you are expecting to live in the property, and you're going to put $5,000 earnest money to be wired to escrow within 2 business days of acceptance. We are not putting any additional deposit. You are getting a loan for $336,000. There is no promissory note or assumption of an existing loan. $79,000 will be the amount that you pay roughly. There's going to be some lender charges, some escrow fees, etc. that'll probably change that amount a little bit. But for the intents and purposes of your loan, roughly $79,000 additional to close for a total purchase price of $420,000. So the $5,000 is part of this down payment portion. It's not additional. It's not on top of that, and it doesn't go away. It is part of the money that you're bringing to closing. So $5,000 plus the $336 plus the $79,000 is $420,000. Initial there for me. Perfect. Great. And we move on. New loan application will be completed within 5 business days. We are going to have an appraisal contingency. It just says our appraisal has to be in no later than 14 calendar days following the date after we accept the RPA. So if the seller accepts our purchase contract today, then tomorrow we'll start our 14-day clock. And that's how all of our timelines are in the purchase contract. The loan contingency will be a 7-day period after that. So that's going to make sure that we have your loan approved with our loan officer, that everything's good with that. So that's, again, 21 days after the day that we accept the contract. This isn't a cash purchase. If it had been, you would have provided proof of funds within 2 business days. You're not selling another house to buy this one. Fixtures and personal property. So this one I like to have my clients read, Mr. Buyer. So from here, from 2 on, if you would take a minute just to read from electrical down to alarms. And agents, I give them a minute, and then they'll say, okay, great, thank you. Now, you expressed that you wanted to ask for the existing stainless steel Samsung refrigerator, the existing Whirlpool white front load washer and dryer with the pedestals. So we've asked for that personal property there. We're going to have title with Ty-Court Title with Regina Esposito as our escrow officer, and initial here. Great. So agents, a little aside here. I never want to see you put here as per MLS. That means nothing. It does not protect you. It does not protect your client. So save yourself the hassle and headache of a problem by always being descriptive in this field. If I, for example, were selling an $800,000 or $1 million home or a $200,000 house, I don't know, that had, for example, Wolf, Sub-Zero, Viking equipment in the kitchen, you better believe that when I was showing that house, I was taking pictures of the serial numbers located inside the door of each of those items, the warming drawer, the stove, the microwave, anything in the house of a real expensive nature like that. And I would be photographing those things to make sure that I had the serial numbers as an addendum to the purchase contract, which I would then attach as part of our offer. So everything you can do to protect yourselves by being as descriptive as possible with this particular type of property, the better off you are. Because these sorts of things, if you just said washer, dryer, fridge, well, you may close escrow and find a 1982 Bisque Frigidaire refrigerator in place of the beautiful existing Samsung that was there. And then now you have to go into litigation or mediation to try to arbitrate that or mediate that issue. So earnest money upon acceptance, the buyer is going to deposit that money, and if applicable, that money shall be deposited pursuant to Section 1, which we already discussed. Mr. Buyer, we're going to close escrow on 3/9. That's what you said was going to work for you. So that'll be the day that you actually move into the property. This is a seller disclosure about the IRS. The seller's going to provide you with title insurance to verify the property has clear title. You won't have to worry about liens, clouds, judgments, encumbrances on the title. Buyer's due diligence period, we're going to get 10 days from the day after we accept the contract, or the seller accepts our contract, to do the inspections of the property. And this goes into the types of inspection that you can have done of the property. You can have the property inspected to your satisfaction, so long as that inspection is by a licensed contractor who is insured, and as long as that inspection is non-destructive, non-invasive, meaning we're not going to cut holes in walls, we're not going to pull back carpet, we're not going to do anything to damage the existing structure or condition of the property, and we can go over the types of inspections in a minute. Your obligation to resolve your objections during that due diligence period, and if you fail to resolve the objections during the due diligence period, you could potentially lose your earnest money. Inspections, this just goes into the inspection, initial here, goes into the inspection portion, which we're going to kind of go to the next side, but just talks about the seller's going to have those utilities functioning for us, gas, water, power. And again, it just recommends here that you use licensed professionals to conduct the inspections. Now, you'll see here that we have home inspection paid by you, roof inspection paid by you, which agents, I don't know how that happened, that should say waived. Mr. Buyer, home inspection paid by you, and pool inspection paid by you. Everything else here is waived. The home inspector is going to do a general inspection of the property to make sure that the property is in good condition. If he sees a need for something like, for example, a roof inspection, he's going to refer you to a roofing contractor. Or if he says, hey, you know what, I inspected the pool, and I think there's something wrong with the pool pump or equipment, he's going to recommend we have a pool contractor look at it. The same thing for the other items that we waive through here. If it's indicated that we need to have those things inspected, we will do so during that 10-day due diligence period, or we'll need to ask for an extension. And sometimes, Mr. Buyer, you get into it and the home inspector walks out sweating and afraid because the house is just literally falling apart. He's going to tell us that, and at that point you may decide that you just don't want to buy the home. So we'll cancel escrow within that 10 days due diligence period and get your earnest money back for you. You can request repairs, even if the property is sold as is. You can request them. It doesn't mean the seller has to agree to them. Anything that's prorated, any fees that can be prorated, will be paid as agreed down here. Escrow fee is typically split 50-50. You'll pay the lender's title policy. The owner pays the seller's title policy. The real property transfer tax is paid by the seller. We'll pay for the appraisal as well. Other things like SIDS and lids, bonds, etc., those will be prorated at the close of escrow, so the seller gets repaid for anything they paid in advance, and you only pay for the time that you've owned the home. We'll get a copy of the preliminary title report showing us any liens, judgments, clouds on title, etc. Have your initial there. You're not asking the seller for any closing costs. We are going to get a home warranty. Now, the home warranty is optional. If you decide not to get the home warranty at any point before closing, you can cancel that. I've overestimated the cost of the home warranty at this point, so that if you were to decide based on the home inspection to add additional coverages, you could do so. The name of the company does not necessarily need to be chosen at this moment, but we do want to disclose to you that amount so that your lender will let you pay for that home warranty as part of your closing costs. Transfer of title will take place at the close of escrow. You are buying into a homeowners association, so it's important you understand the rules of the association, their budget, bylaws, etc. The seller is required to pay for and provide a copy of the the resale package as part of your due diligence period. And again, you will have 5 days from the day after acceptance to review, accept, or reject those documents. HOA-related expenses or CIC-related expenses, the seller will pay for the demand, the capital contribution, the transfer fee, and there's really nothing else there. We're asking the seller for a copy of the SRPD. That's the seller's disclosure to you in good faith as to their knowledge of the condition of the property, and of course if there's been any construction defect related to the property. Initials for me there. Great. Agents, just as an aside, if you had questions, for example, I had a property we were concerned might have scorpions, I would check this box here and probably address it as well in additional terms. Just says here that the seller is to disclose any knowledge of, wood destroying pests, scorpion infestation, anything that you may have concern about, you can put there as for the disclosure you'd like the seller to address. Federal Fair Housing Compliance, Mr. Buyer, this just says that we cannot discriminate based on anything other than your ability to purchase the property. We're going to perform a walkthrough 3 days prior to close of escrow to make sure the property is generally in the same condition it was at the time of the home inspection, and that any repairs that we requested to be done were done prior to closing. Delivery of possession, you will take possession on the same day title is transferred, which is the close of escrow date. In the event the property burns to the ground, you don't have any real claim to it. The seller and the insurance company will duke that out. You can't assign this agreement. If you want to cancel the agreement, you have to do so in writing. You agree to mediation in the event of any dispute between the seller and yourself or between the brokerages, etc., and that saves everybody some money there. If the seller defaults, you have to sue them. You have to take them to court and sue them for what's called specific performance. Not something that we see very often, but certainly could happen. If you default, the seller gets to keep your earnest money as liquidated damages. They can't sue you for actual damages. They can only take you for that. Now, I'm not saying they can't sue you, but that's what the contract's asking for. Instructions to escrow just says that if any part of the, this is the instruction to escrow, I'm sorry. This is the portion the escrow company uses for their instruction to tell them how to handle the contract on our behalf. Again, they're an intermediary, neutral third party that does not play favorites one way or the other. They're also not attorneys, and they didn't prepare the contract. So this talks about the broker compensation fee. This is the fee that our company charges you that I talked to you about when we started looking for homes. It's that $395 that you pay as our document compliance fee. It helps us stay compliant with the state. Waiver of claim in the event that when you close escrow, you're taking the property as is, where is, meaning you can't call the seller 3 days after we close and say, hey, my AC isn't working, I'd like you to come have that fixed for me. Definitions, everything in the contract in bolded items, and bolded text is going to be described and defined in here. Initial form at the bottom, this is continuation of those definitions. We do take facsimile, copy, signatures, DocuSign, all those are legal here. You are not doing a 1031 exchange. Time is of the essence, no change in the contract without the mutual consent of both parties. Initial form at the bottom, great. This is a legally binding contract. If you have questions about the contract, tax implications, etc., we recommend you seek the advice of counsel that's competent in that area. This is just a confirmation of agency. This talks about the fact that I represent you and only you at this point. The property, I don't have a vested interest in the purchase other than as your agent. We're asking the seller to respond by 6 p.m. tomorrow, or you may not be required to be bound by the contract. The seller doesn't have to respond by that time, but if they are late, for example, we can continue with the contract, but it doesn't require them to respond. We can't force them to respond any sooner than they decide to. So signature there for me, date and time. Now, agents, the time span between the signature and initials on the duties owed which was the very first page we signed, and the signature and time on the purchase contract should have, I would say, at least 10 minutes lapsing between the two. You certainly want to take some time to go over the duties owed, but you also want to show that this wasn't signed at 3:46 p.m. and this was signed at 3:47 p.m. because, frankly, how could you have explained the duties owed, let alone the preceding 9 pages of text? In the event that we had an addendum attached, for example, agents, if this was a short sale, or like I talked about, that personal property component, if you were asking for the seller to include anything that's washer, dryer, fridge, etc., and you needed to include serial numbers and makes and models and things like that, you would put that here, that you were attaching an additional sheet, basically, to break those numbers and that text down. Little things here, additional terms. What could we put in? Seller to have property professionally cleaned at the close of escrow. So you would put that there. You don't want to get into legalese. You don't want to be using things like therefore, herein, whereto. You're using plain, simple, everyday English. And please check your spelling and make sure that this is not making you sound like an attorney. Okay, we're not creating attorney or legal documents. We're simply providing instruction for the parties to agree to. So the buyer would sign here, initial at the bottom. Don't forget that one. Sometimes people do. And then, of course, they would also initial at the bottom of this page. Now, in this situation, I used one of our own listings for illustrative purposes. This would be the opposite, the opposing agent or cooperative agent's listing agent's information. I've mentioned throughout the contract that I'm not having the seller enter into a contract with a dual agency or we aren't represented buyers and sellers. In this situation, for, again, illustration, we were, but this would have the listing agent's information here so that the seller could answer these questions. Now you see here that I've checked marked does not, and I've checked marked that the seller is not subject to foreign investment. In both those situations, I got that information from the MLS. Certainly the seller could correct that information if that was incorrect. And then, of course, I've put the seller's information here from the tax record. I think it's important to make sure that you're using, that you're very professional in your preparation of your offers, that you're providing as much information for the other agent as possible. I think when I have an offer come over that looks like this with all caps, you notice everything I wrote was all caps. Whoops, we lost our, come on, there we go, we're in focus again. Everything I wrote here was in caps. I think writing in all caps is a better, cleaner presentation. We did not leave any blanks. You'll notice a page of blanks. You'll notice on the purchase contract there's a zero or some kind of text input in every field as we go on down. Leaving blanks opens you up to liability, so you want to make sure that you're always filling in a not applicable or a 0 or a 0.00 or an NA or something in those spots, because you don't want the other party to be able to fill something in that you didn't see or anything like that. So obviously, if you have any questions, comments, or concerns, any questions, comments, or concerns, you let me know. That's why I'm here. That's why you've hired with us, because you like what I have to say. Maybe you don't always like what I have to say, but you know I'm always here to represent your best interests and make sure that you're getting the right answers to protect you as a practitioner, to protect me as your broker, and to protect our clients so that they're happy with you and want to refer you lots and lots of business over your very long career. So again, not to take the place of understanding these documents. Please look over the documents once a quarter. Please, at least in your initial first few weeks of licensing, or as you become confused, always come to me with questions, because I want to make sure you have the right answers so that you're providing the right information to your clients. I hope you have a wonderful day. I hope this video has been informative to you, and talk to you later.